folks, and welcome back to Contract Law. This is video 2 in the series of videos for contents of a contract, and we have just finished our introductory video and we now need to jump back into our Prezi. So here we go, and we are looking at the rules of the game. So as we saw in the introductory video, it can all be a little bit confusing to work out exactly what the terms of the contract are. Often the terms are going to be disputed and they'll be floating about all over the place, and that's why we started this video series with a little look at where can you go to find out what the terms of the contract might be. They may be wholly oral, they may be wholly written, they might be partly oral and partly in writing. They might be clear on their face, there might be ambiguity in the terms. So there might be a whole lot of issues and difficulty in working out what terms govern the parties' bargain. The parole evidence rule, this is why I say keep calm and follow the rule. The parole evidence rule is really all about trying to introduce a little bit of certainty into the game, as I've lovingly called it. It's a rule of evidence that does a couple of things. First and foremost, it tells you what's in and what's out, okay? What terms are included, what are not. It's also kind of evolved into a rule that assists construction of contract terms as well, interpreting what they mean, and we'll look at that towards the end of this video. So it can be stated fairly simply, and if you have a look on Google for images to do with the parole evidence rule, you'll find all these complicated diagrams. It's actually not that complicated. What's it there for? It's to stop all of the argy-bargy that goes on in trying to dispute the terms. So it stops dissatisfied parties trying to introduce extrinsic or parole evidence, oral agreements, prior drafts of documents, letters, things that have been used in negotiation to affect the terms of what's ended up being a written contract. Okay, so the parole evidence rule is for written contracts only. Okay, applies only to wholly written contracts. It is presumed that the writing contains all the terms of the bargain between the parties, and therefore evidence is not going to be admitted of any previous agreement which would have the effect of adding to the written agreement or varying the written agreement in any way, and that was established by the Mercantile Bank of Sydney and Taylor case. So this rule is sometimes called the Four Corners Rule. The intention of the parties in relation to the bargain and the terms that are going to govern the bargain is gathered from the four corners of the instrument, the written instrument. Okay. The other thing that might assist in terms of finding out what terms govern the parties' bargain is what's called an entire agreement clause, and this is basically just an express form of the parole evidence rule that gets chucked into contracts, usually as a boilerplate clause at the end of the contract, in the kind of like the fine T's and C's at the end there. They're sometimes called merger clauses. They're discussed in the text, so I'll leave you to have a little look at those. But they're just basically an express form of the parole evidence rule. They say that there's nothing else out there, no earlier representations, warranties made by either party are intended to be incorporated in this written document. The written document is, for all intents and purposes, the holy text, the Bible of the bargain. It's the Bible of the bargain. And plain and simple, anything else is irrelevant. Okay, so fairly easy to state, but there are a number of different qualifications and exclusions, as we normally find with these kinds of things. So the first thing you'll notice on my slide here is Mark Jarman's lovely ninja. I call him my no evidence ninja because he's obviously fought valiantly to get the evidence before the court. It's all colourful and everything else outside the line is excluded by the parole evidence rule. Okay, so the first way that you can try and get extrinsic evidence of potential contract terms in front of the court is by saying, well, actually, if you have a look at things, if you look at the context of what occurred between the parties, you will see that in actual fact, the parties did not intend their bargain to be governed wholly by the written terms, because the parole evidence rule only applies to written contracts. Okay, so the first logical thing that the courts will do before they go ahead and apply the parole evidence rule to lock down the parties to the four corners of their instrument is that they'll see, well, okay, is there something else oral that is floating around in the matrix or some other extrinsic evidence that it does seem like the parties intended to have contractual significance. And if that's the case, then the parole evidence rule just will not be applied. So we have a couple of cases that demonstrate this. The first one is the Hospital Products and US Surgical Corporation case. In that case, we had a distributorship agreement that was bargained for, and about a month before the written terms were finalised, you had this representation that was made, an oral representation that was made. So as you can imagine, if parties are bargaining, one party wants their product distributed, the other party is saying, yep, okay, I would really like to distribute your product. It's going to factor on into your considerations as a person that wants to sell their product, whether or not the distributors are going to be selling competing products to yours. Because if they are, well, it's not going to make that distributor as attractive as they might otherwise be. That was the case in the Hospital Products case. The non-compete term that was discussed about a month before the contract was finalised was actually held to be promissory in nature. It was intended to have contractual significance, and therefore it was swept in as a part of the contract terms between the parties, and the parole evidence rule did not lock that representation out. Van den Eschert and Chappell is just the more traditional kind of case where you had a sale of a house and the purchaser, not surprisingly, says, is it affected by white ants? The representation is made, no, it's not, and inevitably it was infested with white ants. The purchaser had to get the house treated and so forth. And what did they do? As you do, you sue. This is 1960, by the way, so I guess litigation was cheaper. And it was held that the verbal assurance was part of the terms of the deal. So that's the logical first place that courts will start. Before they even apply the rule, they will have a good look at the context to see if there's something that indicates there is more than just the written terms on foot between the parties. If, however, you have a purpose-driven contract that has been written between the parties, then it's less arguable that, you know, the other human elements that are floating out there besides the written terms will be swept in. Nemeth and Bayswater Road, prime example, hire of an aircraft, fairly serious undertaking there. There was an entire agreement clause, and it was held that the written terms were going to govern. Everything else was locked out. Gordon and McGregor, the same kind of thing, commercial sale there of some timber. So that's the logical first place. Before the rule has even been applied, the courts will say, let's look at the context. Let's see if this is, in fact, a wholly written contract. Okay. So once the court has addressed that preliminary question, okay, they've arrived at the conclusion, yes, this is a wholly written contract between the parties. What are the exceptions that might be applied? First two we're going to be discussing in a little bit more detail in this series of videos. So where you need to demonstrate that there is in fact a collateral contract that operates alongside the main contract. Then the court's going to say, okay, you can give us evidence to show and support your argument as to a collateral contract. Similarly, where you are trying to argue that the court should imply a term, then the court will let in evidence to allow you to try and demonstrate that the term should be implied. As I said, we'll look at those in a little bit more detail later on in this series of videos. The other exceptions that apply where there are oral agreements floating out there that indicate that the parties have agreed that the contract will only operate in a certain way. And this is the case of Pym and Campbell. So we had this demonstration that was given in relation to trying to show how fancy this invention, this new invention was. It had to be given the tick of approval by some engineers. Two of them, they couldn't find one of them at the time that this invention was demonstrated. One of them signed off. The parties, entered into their written contract. However, the second one never gave their approval. So it was allowed, extrinsic evidence was allowed to show that, in fact, this second approval was not given, and of the arrangements that were made that showed that the parties intended the contract would never actually start operating unless you got both engineers to sign off. So that was Pym and Campbell, where you've got an agreement happening between the parties that show that the contract's never going to exist in the first place unless something happens. Also, where you need to introduce evidence to show that the contract is in actual fact invalid. And you'll be looking at this range of issues later on in contract law. Some of them we've come across already. So where you've got a defect like lack of intention to create legal relations, or lack of consideration, there's some kind of incapacity on the part of one or more of the parties, you can introduce evidence to show that. Similarly, the vitiating factors, mistake, misrepresentation, duress, undue influence, unconscionable conduct, misleading or deceptive conduct, all of which we'll cover in this unit. If you need to make an argument that the contract was vitiated by one of these factors, then the court will let in evidence to help you establish that. So there are a couple of exceptions. There's a few more. If you need to show that the parties made some kind of mistake in the contract terms and you need the court to whip out what they call their blue pencil and fix the contract up for the parties, then you'll be allowed to introduce extrinsic evidence to show that. What is the whole process of rectification about? As I said, normally you'll show an error in the document. You need to show these 5 elements. So there's been some kind of complete agreement, written agreement between the parties. There is this mistake that's very obvious on the face of the document. You need to have clear and convincing proof of what the parties actually did intend, and so here is your extrinsic evidence that comes in. Something else out in the context there that shows that the document doesn't match up with what the parties intended. You have to be able to state whatever the parties did intend very clearly and concisely, so that, again, the court doesn't have to get their blue pencil and write a whole novel or reorganize the whole contract. You have to be able to just pop a little clause in to fix things up, and you can't have any third-party interests intervening here to complicate matters. McDonald and Shinko is just an example of that, where parties were, a party was buying a unit off the plan, showed the wrong unit. There was evidence that could demonstrate which unit was intended to be purchased, and the court was happy enough to get out their blue pencil and fix the thing up, fix the contract up. The last, but certainly not least, of the issues we need to discuss in relation to the parole evidence rule is where it assists the court in construing the contract terms. So this is where the parole evidence rule has kind of morphed over the years into having a second limb of operation, if you will. So the first limb helps the court work out what was intended to be in and out of the contract. The second kind of limb of the parole evidence rule gives the court a bit of assistance where the terms that are in are somehow unclear. So you're not going to find the court applying the parole evidence to lock the parties down to the four corners of their document if the document is unclear as to really important stuff, like one of the big 3 Ps, so the property or the subject matter of the contract. If there's ambiguity there, more than likely you can introduce extrinsic evidence to clear up the problem. So in White and ANZ theatres we had some disputes between artistes. Some actors were brought in to provide a range of professional services and they were defined in the contract as acting, performing, singing, dancing, or otherwise exercising their talents. And the argument was around whether or not they got to produce the show as well as act in the show. Obviously, the defendant didn't think they were doing a very good job at producing and brought in a new producer, which ticked off the actors significantly. And so White ended up suing. And alleging that ANZ theatres were in breach for bringing on the new producers. It was held that yes, the theatre was in breach and that production of the theatre review was in fact part of professional services as defined in the contract between the parties there. So you can see where it's something fairly important like the subject matter of the contract, the court's going to let in the evidence there to resolve the ambiguity. ACOT and Rathmines, more traditional kind of case. Again, just another example where there was a contract for purchase of Unit 115. You couldn't work out which particular Unit 115 was, but there was extrinsic evidence that could help the parties work out what was involved there. Intended parties, so another one of the big 3 Ps, where you've got some ambiguity in relation to that. The court obviously wants to try and help the parties save the contract, and extrinsic evidence can be led in order to fix the problem. Also, where you've got a lack of clarity around another one of the big 3 Ps, the parties to the contract, then the court more than likely will let in some evidence to fix up any problem there with clarity. Edwards and Edwards, we had a deed that gifted some property to a John Edwards. The problem was that the deed referred to 3 different John Edwards and was signed by a John Edwards Jr. And so obviously the court let the evidence in there to point to the particular John Edwards that was intended to be the recipient. Abram and A.V. Jennings. Abram and A.V. Jennings was just another example there where there was a lack of clarity around whether Mr. Abram was entering a contract in his personal capacity or his company's capacity. Not really hard to get your head around this little part of the parole evidence rule. If there's a problem with clarity, let in some evidence, fix up the lack of clarity. However, it has spawned some rather tortured decisions over the last 10 years. Why is that? Because the parole evidence rule, as I said at the beginning of this video, is designed to introduce some certainty, lock the parties down to the 4 corners of their contract. Everything else pretty much is irrelevant. There are a few defined exceptions which will allow extrinsic evidence to be introduced as to have some impact on, augment, detract from the terms of the written agreement between the parties. However, if you say you're going to let in extrinsic evidence to fix up ambiguity, the logical question, and here comes our ninja skills, our no evidence ninja skills, the logical question then is, if you want to get some evidence in, how much ambiguity has to be apparent from the face of the contract before you can get your extrinsic evidence in? Because obviously if there's something very trifling and you can all of a sudden introduce your parole evidence of other things that are happening around the edges of the contract, it's going to significantly water down or weaken the parole evidence rule. So good old Justice Mason in Cadelpha Constructions tried to tighten up things. And he said in that case, the true rule is that evidence of surrounding circumstances is admissible to assist in the interpretation of the contract if the language is ambiguous or susceptible of more than one meaning. But it's not admissible to contradict the language of the contract when it has a plain meaning. So, does this mean that you are locked down to a very literal reading of the contract, and it's only where there's some problem with clarity from the face of the document that you can then get your extrinsic evidence in? I know this much is true. You're going to have a very literal reading there of contractual terms, aren't you? The parole evidence rule is going to apply in most circumstances unless there's something quite apparent from the terms themselves that needs fixing. Now, because of that reason, the UK has shifted away from the way that we tend to approach things, and they've said that that whole part of the parole evidence rule just doesn't apply. They have no true rule in the UK. You don't have to have something apparent hitting you in the face from the terms of the contract themselves where there's ambiguity or lack of clarity before you can get your evidence in. They're a little bit more lenient. However, after Cadelpha, so post the 80s, we've had, as I said, this tortured history of the High Court kind of bouncing backwards and forwards about whether or not Mr. Justice Mason's true rule is still alive and well. In the Royal Botanic Gardens case, so by 2002, the High Court said, well, okay, there might be a little bit of lack of clarity here. Yes, the true rule issue kind of does lock us into a very literal approach to construing a contract. Yes, there's been this shift in the UK, but whatever is the case over there, until we've got this definitive ruling from the High Court here, you've got to stick with Cadelpha. You've got to stick with that more literal approach to the parole evidence rule. You've got to lock the parties down. You've got to try and give some effect to the spirit behind the parole evidence rule. Okay. Then in the Pacific Carriers case, you had this kind of almost yes vote to moving towards the UK way of doing things, and in that case the High Court held that contracts must be construed objectively by the text and surrounding circumstances. The text and surrounding circumstances. So obviously that tends to imply that where you are having problems with construction, you can just get your extrinsic evidence there. No problem with the parole evidence rule. A couple of lower court decisions then thought, oh, okay, that's the way the High Court wants us to go. We'll go down that track. Franklin's was one of those kinds of cases. However, then in 2011, you got the High Court kind of going, whoa, hold on a second. We didn't actually mean to do anything really in Pacific Carriers. That we had 3 judges there holding that approach was inconsistent with the true rule from Cadelpha. Oh, I hate that, sorry. Then in 2014, you kind of had this rethinking going on again in the electricity generation and Woodside Cave. You had four High Court judges there holding that construction required consideration of the language used by the parties, surrounding circumstances, and the commercial purpose. Okay, so we seem to be floating back towards the UK way of doing things again. Again, the lower courts tended to follow that for a little while. And then in 2015, we had the Mount Bruce mining case, and in that case, all the High Court judges there agreed in relation to that 2011 case, the Western Export and Jara case, that was just actually an application for special leave to appeal. And they said, whatever we say when we hear an application for special leave to appeal, it doesn't create precedent. It's not going to bind anybody. So, you know, I guess the position is that we are still currently unclear I would suspect that this is on the High Court's list of items that it wants to resolve in the near future, so I'm guessing that they will grant special leave to appeal in a suitable case sometime soon, hopefully. That will clear up for us whether or not we're going to be applying a more relaxed approach to letting in parole evidence to clear up ambiguity, or and therefore we are going to just say, well, as a matter of course, when we're construing a contract, we're going to look at the terms plus the surrounding circumstances, or whether they're going to stick with that true rule approach and you know, lock down the parties to the written terms of their contract, unless there's something that kind of from the terms of the contract hits us in the face as being problematic. Until we get that High Court decision that defines definitively.
Allow myself to introduce myself.
Solves the issue, then I guess we've got to stick with that true rule approach. So if there's plain meaning, you can't introduce evidence as to your surrounding circumstances. But if there is patent ambiguity, then you can adduce evidence of your surrounding circumstances. So that is the rules of the game. That is the parole evidence rule and all of its preliminary questions and exclusions. And that's about it for me now. I'll finish this video here and we'll come back for video 3 in this series on contents of a contract. So until then, bye guys.